Business organizations, the board of directors of a corporation, their appointment, authority, and responsibility. The state incorporation statute vests authority to manage the corporation in its board of directors. The board of directors is appointed by the company's shareholders. Ultimate authority over the corporation's operations is not held by the owners, the CEO, or any individual director. Power rests with the board of directors acting as a whole, a single body. An individual director has no power acting alone. The authority to manage the company rests with the board acting as a single decision-making unit. There is an exception. Shareholder approval is required for decisions such as the sale of the corporation, sale of all the company's assets, creation of new shares, and other fundamental issues. The size and makeup of the board is defined by the corporation's articles and bylaws. There must be a minimum one director in Delaware and some other states. As each board member holds a vote, and the board acts as a single decision-making body, an odd number of seats is recommended to avoid deadlock. The board often consists of 1, 3, 5, 7, even 9 members, depending on the size of the company and the wishes of the shareholders. A good deal of control is exerted over the corporation via the board seats. Venture capital and other shareholders often require seats on the board and make their investments in the company contingent upon restructuring the board via amendments to the articles and bylaws. Deadlock occurs where votes are evenly split, so the board of directors or shareholders are unable to make a decision. Deadlock on the board can only take place when the board is comprised of an even rather than an odd number of directors. When asked to remedy a deadlocked board situation, the court can appoint a provisional director. This transforms an even board to an odd number of seats, and the provisional director's vote usually breaks the deadlock. When asked to remedy a deadlocked shareholder situation, the court can order involuntary dissolution of the corporation. To avoid dissolution, one group of shareholders often buys out the other group of shareholders by paying fair market value for the shares. Where a member of a corporation's board of advisors has no fiduciary duties and no significant potential liabilities result from joining the advisory board, the potential liabilities that attach when joining a corporation's board of directors can be substantial. Directors acting with reasonable care and loyalty to the company are protected from personal liability by the business judgment rule. But when the board acts with gross negligence, the individual directors can find themselves personally liable for harm suffered by shareholders as a result. In the Smith v. Van Gorkum case involving the board accepting an acquisition offer without researching the offer or the alternatives, the directors were held liable to the shareholders for $23.5 million. As the compensation paid to the directors is usually in the 4 or 5-figure range, their remuneration is dwarfed by the potential for 8-figure liability exposure to shareholders. Directors' and officers' insurance is available, but can be costly, and insurers often refuse to cover small corporations without established governance procedures. The heightened duties assigned to directors of public companies under the Sarbanes-Oxley regulations and the associated civil and criminal sanctions are seen by many as a deterrent to individuals joining a public board of directors. Directors accepting board positions are advised to take their responsibilities seriously. This is the message from the Van Gorkum Delaware Court and other U.S. courts that have addressed similar issues. Directors with the highest shareholder vote are elected to the board of directors. Under straight voting, each shareholder has one share to vote to fill each director's seat. It's easy for a minority shareholder to get outvoted for each seat under straight voting. With cumulative voting, shareholders are able to cumulate all votes for one single director position and not to use any votes on the other seats. A minority shareholder has a better chance of electing a director in this way. Cumulative voting for the appointment of directors is often found in the bylaws of smaller corporations. Directors are appointed and removed by a vote of the shareholders, usually at the shareholder meeting. Bylaws can define how this operates for a particular corporation. A majority vote of shareholders removes a director. However, cumulative voting is required to remove a director if cumulative voting was used to elect the director. Otherwise, a director appointed under cumulative voting by a minority shareholder will be easily removed by straight voting of the majority shareholders immediately upon taking office. With the exception of a staggered board, cause is no longer necessary grounds for removal of a director. However, a board member does continue to hold a right to reasonable notice and disclosure of the reason for removal. Although the board of directors usually acts as a single decision-making body, the board is able to delegate power for specific matters to a specialist committee made up of board members. Audit committees, executive compensation committees, and nominating committees, nominating new directors, are very common in large corporations today. These committees consist of only a subset of board members, but carry the powers of the full board. There is an exception. Fundamental matters such as a sale of the company, sale of substantially all the company's assets, amendment of the articles or bylaws, requires full board approval and cannot be delegated to a committee. The law recognizes the board of directors as the corporation's decision-making body. It's unlawful for directors to enter agreements to vote in a certain way. Such agreements would be rendered void as against public policy. Directors must be free to vote in the best interests of the corporation, under the conditions at the time the decision is made. Voting agreements that tie the hands of the board of directors are not enforceable at law. There is an exception for specific narrow decisions like the appointment of the president in a closely held corporation with few shareholders. With a staggered board, board members are rotated. Not all board members are elected each year. Each year, only certain board seats are up for election. This prevents radical overnight changes to the makeup of the board and safeguards some degree of consistency. It also acts as a poison pill, restricting the potential for a hostile takeover. In the state of Delaware, members of staggered boards can only be removed for cause. As we will see in another slide, cause is not usually necessary for removal of a director today. But under Delaware law, a director must have breached fiduciary duties to the corporation in order to be removed from a staggered board. Venture capital investors usually require dedicated board seats. Board seats are often reserved for each class of stock. Series A investors elect a board member, Series B investors elect a board member, Series C investors elect their own board member. Common stockholders, the founders and employees, also often elect a board member. In this structure, it's difficult or impossible for investors to lose control of the board of directors and lose their influence over the company. Board seats become vacant upon the death of a board member, resignation, and for other reasons. A new director can, of course, be appointed to fill the vacancy by a vote of the shareholders, of course. But this sometimes involves delay. It may sound unusual, but the board of directors has the power to appoint the director to fill the vacant seat, even when the board lacks a quorum due to the vacant seat. State statutes encourage the vacant board seat to be filled without waiting for the next shareholder meeting. If the shareholders don't fill the seat, it can be filled by the other members of the board. The board of directors appoints the officers of the company, responsible for day-to-day management. The President, CEO and CFO are all officers. Although they own the corporation, shareholders lack the power to appoint officers themselves. They can, however, appoint the Board of Directors and make recommendations to the Board of Directors, nominating officers for consideration. The Board of Directors delegates management of ordinary company business to the officers, but the Board remains responsible to the shareholders. The officers can make day-to-day decisions, but they require Board approval for decisions outside the company's ordinary course of business. A decision of the Board of Directors may be ineffective if Board members were unable to vote or the Board lacked a quorum. A Board member may be unable to vote when a special, unscheduled meeting of the Board is convened without providing notice to all the Board members. Notice is necessary for a special meeting, but is not necessary for regular, scheduled Board meetings. If a Board member is not in attendance at the meeting, but votes by proxy, this vote is ineffective. Board members have to attend the meeting in order to vote. The exception is where all Board members submit a written vote. A written vote is effective if it comprises all the members of the Board. A written vote by some members, but not all, is ineffective. The rule requires all or nothing. All members vote in person at the meeting, or all members vote in writing. If there are an insufficient number of directors present at the meeting, their decisions may be ineffective on the basis that they lacked the required quorum. A decision is effective when made by vote at a meeting attended by a sufficient quorum of the Board of Directors. Attendance at the meeting can be in person, but attendance is also accomplished by phone or teleconference today. The exception to the requirement of attendance involves a written vote by all the directors. Usually, attendance at the meeting by a majority of authorized directors is sufficient to form a quorum. So if 3 out of 5 directors attend the meeting, the quorum requirement is met. The quorum requirement can be customized for the corporation in its bylaws. The proposal is presented to the Board. All in favour are invited to say aye, all against are invited to say nay, and the vote is made. The decision is subsequently recorded in the Board minutes. There are situations where the Board can be deemed to have acted without actually acting. If a majority of the Board of Directors is aware of a decision of management and does not call a Board meeting or otherwise object to the decision, the Board is usually found by the courts to have ratified the decision of management. Board members must, however, be informed of the details. This sometimes arises when the CEO decides to acquire another company, but fails to call a special meeting of the Board of Directors to approve the acquisition.